Welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm your host, Steve Barnes. Joining us today, we have Polk Wagner, a professor here at Penn Law, who will be speaking about the critical importance of intellectual property and patent law to modern commerce today. In fact, in February, he's helped launch new online courses in IP and patent law and policy, which are open to participants all around the world. Professor Wagner, thank you so much for joining us. So let's talk a little bit about some of the online courses you're offering in February, this spring.
Yeah, so this spring we're offering basically 3 different online courses. The first, and the one that began first at the beginning of the semester, was one called Patent Law and Policy. And that is intended to be a fairly in-depth review of the patent system and the law and policy of the patents. And really what that is taking the classes that I actually teach here at the law school and moving that online as much as we possibly can. The other 2 courses that I'm doing this spring are Introduction to Intellectual Property Law and Policy. Those are a bit different in that those are created entirely for the online environment and entirely to be MOOCs, so massive open online courses. Those are both sort of overviews of the intellectual property law system and the policies surrounding it. It's split into 2 because IP is such a big topic and lots to cover these days. So we start in the first one doing patents and sort of the overview of the policies, and in the second one we do copyright and trademark.
Great. So just to step back for a moment, what is, this is a big question, but as briefly and concisely as possible, what is intellectual property and patent law? And if I may, to make things even more complicated, what are the value of IP and patent law in modern commerce today? 2 very easy questions.
Sure, yeah. So first of all, intellectual property law is essentially the study of that series of laws that deals with intangible property rights. And what sort of binds all of intellectual property legal systems together is the idea that you're using this regulatory system to make a property rights system out of something that is at its core ideas, either ideas related to creative expression or ideas related to invention, ideas related to branding and logos and goodwill. All of those are what intellectual property law is. The reason it's important is that this, it's particularly important for lawyers in the U.S. and other places, but especially in the U.S. because this is what we do now in the modern economy. I mean, the manufacturing in the U.S. has rebounded a little bit in the last few years, but in general, what the United States does is ideas, right? We make inventions, we make films, we make pop products, we make multinational corporations that use branding. That's what the United States does now, much more than manufacturing. And so because of that, understanding intellectual property law, which is at its core the policies that we have decided as a society to pursue to promote, encourage, protect that innovation, that invention, is really, really important.
Right. So for some context, could you provide us with maybe an example or 2, perhaps something from the multinational or business side of things and perhaps the purer sense, and also maybe one of the more pop products up to and including, say, pop music, cases where intellectual property or patents cases have moved forward, and perhaps, again, to flesh out some of the broader context here.
Sure. Well, I mean, some of the well-known disputes that we've seen lately, or issues that we've seen lately, is for one thing, this continuing transformation in the way that we consume media, for example, right? It used to be that you would buy a VHS tape or go to the video store and rent it, right? You don't do that anymore. You do that now streaming or using your DVR on your TV or something. That shift is both being driven by technology, but also is being intermediated by the legal system, right? The copyrights are what drives who gets to do that, whether you pay $4 or $2 or $100 for those streams. All of that has intellectual property all over it, right? So every time that you interact with your television set, every time that you watch Netflix, that is all intellectual property law that creates that entire industry. On the patent side, I mean, there's tons of examples of this. Just this Christmas, right? The hot toy for Christmas was the hoverboard. The hoverboard now is involved in a huge amount of patent litigation. Because as is the case when there are products that attract a lot of attention and money, people say, well, I invented it, I didn't invent it, and so now the court system has to essentially sort out who invented it, who gets the rights to it going forward, and so forth. In fact, just last week at the Consumer Electronics Show in Las Vegas, the U.S. Marshal showed up at somebody's booth and dragged people away because they had violated a patent. So this is real, happens all the time, and can be extremely current instead of in the sense of the really immediate technology that we see every day.
Certainly seems like a burgeoning, if not a thoroughly vast sector. But to step back even further, in the U.S. context, what is IP in patent law based on? What are the bases for some of the laws in IP and patent law?
So that's a great question. So in general, what we want out of intellectual property laws is more stuff, right? I mean, we fundamentally in the U.S. believe that these laws are created and should be tailored to maximize overall social benefit. And by social benefit, we generally mean more inventions that advance society, new medicine, new technologies, new phones, all of that sort of thing advance society along. In the creative side, we think that more creative goods, more books, more records, more movies that people enjoy and talk about and express their ideas through are also a good thing. Trademarks has a little bit of a more subtle effect, but at the same time there we're looking for more of something, and that more is interesting. So trademarks is a set of laws that links a logo, a brand, a trade name, sometimes a design of a product, to an underlying manufacturer. When you do that, you create incentives for that underlying manufacturer to create a good reputation. Right? If you didn't have that linkage, and anyone could say, for example, put the Mercedes emblem on the car that they just manufactured, then the Mercedes-Benz company would have very little incentive to generate goodwill. And when companies have incentive to generate goodwill, what they do is they create higher quality products because their goodwill is going to last longer and it's worth investing in quality. So just like in patents and copyrights, we're seeking more stuff in the trademark area, and what we're primarily interested in there and primarily getting out of the trademark system is higher quality goods. And so that's how we think about intellectual property in the U.S., and it's all through this lens. Now, one of the most interesting things about intellectual property law is that we don't really know whether we're doing enough or doing perhaps too much. The intellectual property laws are a trade-off. So every time that I grant, for example, a patent right on a new drug, what that means is that drug is going to cost a lot more than it would otherwise, right? The manufacturing cost of that pill, for example, might be $1.50, but instead it'll be potentially hundreds of dollars for that pill because of the patent rights. Now, we think that that's the right thing to do because that repays the investment in research and development that it took, billions of dollars sometimes, to create these life-saving drugs. On the other hand, we don't know. We just don't know whether maybe we're giving too much money to the drug companies in this context or not enough. And it's very difficult since there's never been a time that the U.S. has not had, for example, a patent system. It's written right in the Constitution. So we don't have that counterfactual to fully understand whether or not we're doing the right thing. All developed countries in the world have intellectual property systems that, by and large, look almost identical to ours. And indeed are modeled primarily on the U.S. system. And so it's not like you can go to different countries and say, well, here's one that doesn't have intellectual property, let's see how they're doing. So that's one of the fun and interesting things about studying intellectual property law is that we have a lot of regulation in an area that's critically important to our national innovation policy and, frankly, critically important to the way our country operates. And yet we don't have a lot of empirical data about exactly how it's working, whether it's working, whether we are giving away too many rights or not enough.
Right. So it's interesting, you mentioned that the U.S. system, or the patent system or the IP system in the U.S. is very similar to other systems in other countries. Are there any notable differences?
Well, so I think that there's definitely differences in terms of the way that enforcement works. So for example, all of what we call the continental European countries have different ways of litigation enforcement, less juries, more judges, things like that. But that's fairly common across all areas of law. A big difference between the US and other countries is that some countries, and most notably France, have a slightly different view of what, in particular, the copyright laws should look like. In the US, we believe that the copyright laws are and again, trying to create more of the stuff that people want. In the French tradition, it's more of a idea behind moral rights, right? Where the reason to have a copyright is not so much because we want to incentivize people to create more stuff. It's because we want to reward the people we think are particularly talented, particularly good, the artists themselves. That changes the way that you do the law. It means that you offer a lot more power to artists in terms of their ability to control what people do with their work. You make it much less easy for people to buy and sell artistic expression in those systems. So that's probably, if you looked around the world and saw, a major difference, it would be that we in the U.S. really strongly have this sort of traditional utilitarian approach towards intellectual property laws, which is not necessarily the case in all areas. I should say also there are other areas of the world that take a slightly different view of intellectual property rights, in part because of the state at which their economy is. So if you're a highly developed, advanced country like the US and most of Europe and Japan and some of the other countries that are pretty far along in their development, you want strong intellectual property rights because, as I said sort of at the outside of the interview, this is what you do. You make inventions. You have lots of educated workers. They create things. They invent things, and so forth. That is not necessarily the case for a developing nation, right? A developing nation may not have the educational infrastructure, the financial infrastructure, all the pieces that have to go into having an innovation-driven economy, and yet they may want to get there. And so one of the easiest ways, and this is actually something that the US did when we were actually colonial times, is borrow from the advanced countries, right? So you basically take innovations that have been made elsewhere and bring them to your citizens. You learn from them perhaps, but more importantly, you get your citizens access to all of those innovations as well relatively cheaply. So one of the things that we've seen is that these less developed countries generally have intellectual property laws that reflect their interest, which is to have less intellectual property rights, at least at that stage of their development. And of course, the highly developed countries would like them to have more. So a real example of this, for example, is India, right? So India has a patent law that, although largely mirrors what the US does, has particular kinds of exceptions and sort of carve-outs for pharmaceutical drugs. And that is because what India wants to do is two things. One, develop a local pharmaceutical drug manufacturing and development industry and get access to these drugs for their citizens. That then creates a lot of tension because that means that from the perspective of the developed countries, the Indians are able to get access to a lot of this innovation without, in a sense, paying for it through their intellectual property rights. And so that's, the international sort of tensions that have been going on over the last 2 or 3 decades.
Sure, absolutely. So you and your colleague here at Penn, David Abrams, have been studying congressional reform of the IP and patent system in America, including the America Invents Act, and I believe that Congress is now taking up, patent and IP reform again for the umpteenth time. So where are we now in terms of congressional reform of our system or systems, and what are your thoughts on those efforts?
So it looks like, as sort of we speak here, it doesn't appear that there's going to be much reform anytime particularly soon. The areas of concern and movement and questions right now surround primarily the reform of the way that patents in particular are enforced. And the way to think about this, I think, is to understand that the way that patents are used now is very different than they were 20 years ago. It used to be, a couple of decades ago, you would get a patent because you were making, a coffee mug or something, and you wanted to protect the product on the marketplace, keep your competitors from copying you. Increasingly, that's not what patents are. Patents are instead, it's an asset in and of themselves, independent of any products. And sometimes there are people who will invent things who have no intention of actually making the products. Or maybe they intend to make the products, but they ultimately don't have the skill sets, or they can't find an investor or whatever. So that means that they still nonetheless have this important asset, this patent grant, this patent right, that, like any other piece of property, you can do whatever you want with, right? You can sell, you can rent, you can divide it up, you can do almost anything you want. And so what we've seen is a sort of springing up of new business models, new efforts to exploit these assets as assets, not just as associated with particular products. One of the results of that change in the way that people understand patents is that there's been a rise in litigation, and especially a rise in litigation surrounding what people generally call non-practicing entities. Sometimes people call them patent trolls, but that's a hard thing to define. These non-practicing entities are, because the only way they can make money is by getting licenses or otherwise enforcing their patent rights, tend to be more litigious, more aggressive than their counterparts who actually make products. Now, that's not to say that some companies that make products aren't particularly aggressive either, but in general, non-practicing entities have more interest in enforcing their patent rights, and so we've seen a pretty significant rise in patent litigation in particular over the last several years.
So in other words, critics would probably argue that these non-practicing entities would buy a bunch of patents, and then anytime an inventor or a company goes to take something to market or has something in the market that is similar or the same, they then litigate in order to...
Exactly, and so that's the question. The question, and there's been a lot of studies being done on this, and and some people say that they are a net positive, right? Because you can argue that what they're doing is essentially making it more reliable. If you're, say, a venture capitalist, even if your company that you've invested in craters, there's still patent rights, and you can still exit by selling off the patent rights, so they have real value. On the other hand, they might be a net negative because they're creating lots of litigation. Litigation is generally bad, right? Just it causes lots of costs, a lot of confusion, a lot of uncertainty, takes a lot of time to sort these things out. And I think the right answer now is we don't really know yet. We don't know what the scale of the problem is. We know there's a lot more litigation. Some of that more litigation is because there are more companies generally. There have been times in our history when we've seen rapid changes in technological advancements, say the late industrial age, and we've seen a correspondingly similar rise in patent litigation. And this is because anywhere where there's lots of money to be made in innovation, patent litigation is going to follow. People are going to get lots of patents in those areas, and people are going to litigate in those areas. And that, I think, is to be expected. Now, obviously, one of the things we would like to do from the design of a patent system perspective is reduce as much as possible the litigation, because that's almost certainly a loss. How much we can do that, I don't know, and that's sort of the tricky part. The reforms in Congress have been largely driven by lobbying on the part of the tech industry, who feel particularly at risk right now from patent NPEs or patent trolls or other entities. This is for several reasons. One is there's a lot of money in the tech industry right now. They're creating new products every day, new phones, new other personal electronic devices. Lots and lots of money attracts lots of attention and potential litigation risk. They also, in the tech industry, have products that, one phone, for example, can incorporate inventions from hundreds of patents, possibly. So it's very much unlike the pharmaceutical industry, where you typically have, one patent applies to one drug. And so it's relatively easy to sort out who owns what and what the rights are. This is totally different in the context of, say, an iPhone, where there are 200, 300, 400 inventions in a single product, and you have to sort those out, and can be very, very difficult, very complicated. So for that reason, the tech industry in particular has been very aggressive on Capitol Hill to try and change aspects of the patent system, in particular the way that damages get calculated, the way that litigation is done in terms of where it gets done, how it gets done, more procedural reforms than substantive reforms. So those have gotten some traction. There are bills that are pending in Congress. Nothing that has sort of gone as far as getting both houses of Congress to agree to and move on to the president's signature. The last major reform was in 2011, what we call the America Invents Act. That was a pretty major reform, probably the biggest since 1952 in the patent context. And what that did was basically two things. One, it changed the way that we grant patents to the first person to file for the patent application, as opposed to our old system, which was the first person to invent. And that sort of pretty dramatically changes the way that incentives are for either filing early or disclosing early. Probably changes the effects on big versus small companies. That's the study that my colleague David Abrams and I have been engaging in recently, is to test whether that affects small businesses or individuals differently than big businesses. The other major reform was to have a post-grant review system, which a lot of European countries do. What that does is it allows people, if they think they see a patent that's already been granted that may not be valid, you can file for what's called post-grant review at the patent office, so basically a do-over at the patent office. The intent there is to allow for reviews of patent validity without having to go to expensive federal litigation. So instead of spending $8 to $10 million of litigation dollars, you could spend a third of that perhaps, or even less, to do a post-grant review at the patent office. That has turned out to be wildly popular in terms of numbers. The jury is still out on whether it's effective. It doesn't necessarily prevent later litigation, and so I guess we won't know for maybe 10 years whether or not it's really bringing down the increases in litigation, but the theory is that it should.
Looking at your study about the America Invents Act, one of the questions you and David raised is this going to help or hurt the small inventor? And noting from our conversation now, where the American system is meant to encourage more and better, more innovation, more people, more educated people getting involved and contributing to our society and our economy, as we take a wait-and-see attitude over the next 10 years, how do you see this playing out based on your original analysis?
Well, certainly the anecdotal analysis that we've heard since we published our piece is that we were right, in the sense that we posited that it would hurt small businesses and individuals. The idea here is that when the person who gets the patent is the first one to get to the patent office, that's going to favor people with more resources, people who have in-house patent counsel, people who have staffs of attorneys who can draft a patent application quickly and get it to the office quickly. And it's going to disfavor people who may not know that they should go get a patent, or may not know who to call to begin with. That's what we found in Canada, where we found about a 15% drop in the share of small and individual inventors after the change of law, a similar change of law back in the 80s there. And so we predicted that that would happen here. Anecdotally, we've heard that in fact is happening. It's a little too early, although we were thinking of maybe this summer revisiting that in the U.S. context. It's still a little early. But it might be time to start gathering numbers and see whether we've seen a similar shift away. I think more generally, what you're seeing in the patent system is a real battle about what the patent system, who it is likely to serve. Large tech companies really believe that the patent system should be weakened diminished so that they can innovate more quickly without sort of having to worry as much about patent rights. Pharmaceutical companies and small inventors and universities, frankly, are on the other side of that, and they believe that the patent system, if anything, should probably get stronger because, again, this is sort of the comparative advantage of the United States right now is to have a strong system of innovation, and we would be, in their view, dumb to weaken it right when we are sort of needing it to energize the 21st century economy. That's the fundamental debate, political debate. It's primarily playing out in patents right now, but I think it pertains also, and you'll see a lot of that in years ahead with respect to copyright and trademark as well. So for example, the fashion industry has been pushing hard recently for expansions of the trademark law to allow them to cover more fashion products under the trademark law. Right now, fashion products, clothing and things like that have very little intellectual property protection. That is often pointed to as sort of a puzzle because it's a very innovative area. But it's an area that has particular characteristics where these big companies innovate very quickly. I mean, literally every couple months there's entire new clothing lines coming out. Their argument is to Congress that they would be better, they would have higher quality products, that they would have less sort of consumerism associated with the industry if they could go slower, invest more in product development, invest more in their trademarks. The debate on the other side is they seem to be doing just fine, right? People, it's probably to the net benefit of society that you can see something, the latest design on the fashion catwalk one day, and the next day it's in, Forever 21 or one of these, companies that specialize in taking designer goods and making them very cheaply.
Right. So we've talked a lot about what's going on in the tech sector, what's going on in Congress. So what is making its way to or is currently in the Supreme Court, the U.S. Supreme Court now?
So the Supreme Court is, over the last, say, 5 years, I'd say, become very, very active in intellectual property law. This is unusual. For most of the recent last 50 years or so of Supreme Court history, they have by and large stayed out of the intellectual property area. I think that was in part because it was viewed as a sort of complex and fairly obscure area, neither of which is really true anymore. I think that as the justices read more about intellectual property than the New York Times, they take more intellectual property cases and insert themselves in the major debates. There were major cases last year on the way that patents are calculated, the way that copyright damages are calculated. The bulk of intellectual property law is statutory law, meaning it's written by Congress. So the Supreme Court decisions aren't going to fundamentally change the law, although there was a decision in the Alice, which is well known as the Alice case in the patent field, that did make it much more difficult to get a patent on a software product. And so that's having sort of ripple effects and ramifications that, again, we still don't fully understand, but does appear to be having a real effect. This term, the Supreme Court has taken less intellectual property cases, so far anyway. The ones they have are pretty minor in terms of long-term effects. They're interesting to me for someone who studies the law of patents, what the standard of review is at the patent office for some of these inter partes review or post-grant review systems is a question that is really important to the way that patent litigation works. Probably doesn't matter a ton to sort of the overall innovation economy, but matters a lot to patent nerds like myself. Sure.
So speaking of the innovation economy, sounds like you certainly see this as a hot sector, a growth sector, and one that's just going to continue to get bigger and bigger and more innovative. So where do you see the IP and patent law sectors headed over the next 10 years for the inventor, for the consumer, and also for anyone who wants to work as a lawyer in these sectors?
Yeah, so I'll start with your last point first. So my view is that all lawyers are in some sense now going to have to be intellectual property lawyers. I think that you can't engage in business transactions, or even increasingly some criminal transactions, without understanding intellectual property law. And it doesn't necessarily mean that everybody has to be an IP expert, but at least you need to know these issues. Every time there's a merger and acquisition now, intellectual property rights are at the center of the deal. How do you value them? How do you transact? Making sure that all of the transactions are consummated properly and so forth. Every time there's a early stage investment, right? Do they have patents? Do they not have patents? Do they have copyrights? How are they protected? How are they protecting their trademarks? Those are all questions that even lawyers that you would think of as just deal lawyers, they have to deal with on a daily basis. And so for that reason, what we've seen is that basically every big law firm now, every major full-service law firm has a very, very significant intellectual property practice. And that's pretty different than it was 10 or 15 years ago. 10 or 15 years ago, patent firms, there were patent boutiques, there were copyright boutique law firms, small firms that specialized in this particular area. Those have largely been purchased or merged into larger firms. There's still a few of them out there, but less and less all the time, because increasingly these major multinational law firms are engaging in the practice of intellectual property law. So what does that mean for students? I mean, what I think that means is that part of having a well-rounded legal education is to definitely expose yourself to significant amounts of intellectual property law, even if you don't end up practicing. So one of the things I think we do really well at the law school here is have Introduction to Intellectual Property as one of our first-year electives, and typically get around 70 to 90 of our first-year students, so a solid third or so of the class, take that their very first or their very second semester, their very first year. Which then sets them up to, even if they don't end up being an intellectual property lawyer later, it sets them up to really know a lot and learn a lot about intellectual property in their summer jobs and elsewhere as they go on in their careers. And so I think that is, for me, one of the most important things to consider. For inventors, this is, or for the creative workers, this is a challenging time. The intellectual property laws are changing, not necessarily in the favor of small and individual inventors. And so, you see a lot now, people talking about, your personal brand, right? That all goes back to intellectual property rights. The reputation you have, either online or elsewhere, is important to understand, and how you can and can't protect it. Whenever you consult, for example, now, and more people are doing freelancing or consulting, intellectual property rights have to be a term of that arrangement. And so I think that in general, it is useful for everybody to really understand at least something about intellectual property law. And that's one of the things I'm hoping to be able to do with these intellectual property courses that we're doing on edX, which is expose people, not in a super in-depth way, but in a way that they can now read the newspaper, read the New York Times, the Wall Street Journal, major newspapers around the world, and see these intellectual property disputes and understand them, and know what's going on, and understand where the moving parts are.
That's fantastic. Well, that seems like a great point at which to end this conversation, and for people to perhaps explore IP and patent law through your online courses, through edX and through Penn Law. So thanks very much, Professor Wagner, for joining us. Oh, it's been our pleasure, and I've certainly learned a lot. And we look forward to you joining us next time for the next episode of Case in Point.